Good morning, everyone. I want to talk to you today about post-conviction relief. So, what is post-conviction relief? It's really an area of practice that sits at the intersection of criminal and immigration law. Now, that intersection is very complicated and in many ways very nonsensical. So, why would I say that? I say that because there are low level misdemeanors, things that you might not spend a single day in jail if you were convicted of, that can prevent you for life from getting a green card, or if you already have some type of immigration status, can jeopardize that status. On the flip side, there can be serious felonies, things that you might go to state prison for multiple years, which don't have those immigration consequences. And of course, the consequences of a conviction are not uniform across all of the different types of immigration status, meaning the consequences for a green card holder of a particular conviction might be different than a person who has DACA or TPS, or a person who has no status but hopes to get it in the future. So, the first step in any type of analysis involving criminal and immigration law is to have a consultation with an attorney who's really familiar with this intersection and can advise you if your criminal history actually has immigration consequences. If it does, the next step is to evaluate what type of post-conviction relief is appropriate and available. In limited circumstances, usually involving a DACA recipient, an expungement might be enough. But most of the time, expungements are totally useless for immigration purposes. A second option might be reducing a felony to a misdemeanor. So, California, for example, has a number of statutes that can be prosecuted as both felonies and misdemeanors. And even if the original conviction was a felony, it sometimes qualifies to be reduced to a misdemeanor. This may be very helpful for a DACA or TPS recipient who is barred from holding their status if they have a felony conviction. Now, the third option is a motion to vacate, and this is the most difficult one and the one that is needed when a conviction, regardless of the sentence or regardless of whether it's classified as a felony or a misdemeanor, might have immigration consequences for you. And actually, I'll qualify. Sometimes you can change a sentence with the motion to vacate and keep the same charge for conviction. But either way, what you have to do is you have to go into criminal court and convince a judge that there was a legal or procedural error in your underlying criminal case that justifies allowing you to withdraw your guilty plea now. Now, once again, this is a very complicated area of law in that the immigration authorities don't accept all types of dismissals. And so you have to be very careful to be sure that the vacator order you get from criminal court will be sufficient for immigration purposes. If you have any concerns that your criminal history might be impacting your current immigration status or your ability to get immigration status in the future, please give us a call, 323-475-8716. I'm happy to consult with you about what consequences there may be and what steps we can take in criminal court to alleviate those consequences for you. Have a nice day, everyone.